are mercenaries defined by the Geneva Conventions. Imagine a soldier fighting for a country versus someone hired just to fight for money. Do international laws see these two fighters the same way? That's what we're exploring today. The Geneva Conventions are a set of rules meant to protect people during war. They cover soldiers, civilians, and prisoners. But do they say anything about mercenaries? The answer is yes, but with some important details. In 1977, an addition called Additional Protocol 1 was added to the Geneva Conventions. It specifically defines what a mercenary is. According to Article 47 of this protocol, a mercenary is someone who is recruited locally or from abroad to fight in a conflict. They participate directly in hostilities, meaning they actually fight. Mercenaries are motivated mainly by private gain. They are promised much higher pay than regular soldiers of similar rank. They are not citizens of any party involved in the conflict and usually do not belong to any armed forces. They are not sent by a government on official duty. This definition is quite strict and applies only to international armed conflicts. It excludes many modern private military contractors or private military companies. These companies often provide security or military services but do not meet all the criteria of a mercenary. Under the Geneva Conventions, mercenaries do not get the same protections as lawful combatants or prisoners of war. They are not entitled to combatant status or prisoner protections. However, they still must be treated humanely and cannot be punished without a fair trial. The decision about whether someone is a mercenary is made by a court or tribunal. There is also a separate treaty from 1989 called the International Convention against the Recruitment, Use, Financing, and Training of Mercenaries. It broadens the definition to include people recruited to overthrow governments or undermine a country's territory. This treaty emphasizes that mercenaries are motivated by private gain and are not officially linked to any state. Understanding this helps clarify how international law views these fighters. Mercenaries are seen as a special category with limited rights under the Geneva Conventions. They are often involved in conflicts for profit rather than national interest. This legal distinction impacts how they are treated during war and highlights the importance of accountability. In summary, yes, the Geneva Conventions do define mercenaries, but only under specific conditions. Many hired fighters today do not fall into this category and are governed by other laws. The Geneva Conventions focus on protecting civilians and lawful combatants, while mercenaries are recognized as a separate group with limited rights.